today we have a very recent industry news led us to today's topic. Today's topic is esports salary caps as an antitrust restrictions, And I'm very happy that we could get Fabian today as a guest, who is a doctoral researcher, I believe, and especially in this area of the legal expertise, and also an Of-Counsel with AKELA. And with that, Fabian, the stage is yours.
Thank you, Moritz, for having me today. Thank you to everyone in the audience for being here. I appreciate you taking the time. I know we all have busy schedules these days. So as Moritz already said, I'll be speaking about esports salary caps as an antitrust restriction. First of all, just briefly to set the scene, what are antitrust laws about? Antitrust laws have mainly three pillars. The first pillar is merger control that comes into play when companies try to take over each other. So, for example, if you have two bakeries in your town and one seeks to acquire the other, there may be a competitive concern that the bakery then, after the transaction, has a monopoly on baked goods in your town and might increase prices, say by 50%. Obviously, since we're all trying to save money, that wouldn't be very good for each other, meaning there might be some competitive concern. The second pillar is the prohibition of cartels. Think again about your two bakeries. If they coordinate their behavior by agreeing to raise prices of baked goods every month by, say, 20%, this harms consumers as the bakeries no longer compete and consumers have to pay significantly more. The third pillar, which in my humble opinion is the most interesting one, is the prohibition of abuse of dominance. For this, we require a dominant position in a market, which starts at about 40 to 50% in the EU. However, holding a dominant position is not illegal in itself. It's accompanied with some kind of special responsibility not to engage in conduct that may distort competition. So think again of the bakeries in your town. If you also have a supermarket that has a bakery and it decides to sell baked goods below cost, and the other bakeries then can no longer compete and go out of business, this would constitute predatory pricing. The objective behind this is to drive the competitors out of the market and subsequently charge monopoly prices. In other words, to recoup the money lost while driving the competitors out of the market. This would constitute an abuse of dominance, provided that the bakery in the supermarket has a market share of 40 to 50% in the market for baked goods in your town. From these three pillars, we can generally infer the purpose that antitrust laws are designed to achieve. That is, depending on the decade you're in and the country one considers, these are generally the protection of consumers, competitors, and/or competition. Quite often we have a combination of two or three of these factors. And the issue we'll look at today commences with Section 1 of the US Sherman Antitrust Act, which states that every contract or combination in restraint of trade or commerce is declared to be illegal. Based on this section, the US Department of Justice assessed Activision Blizzard's conduct concerning esports salary caps. So briefly, the facts of this case. Activision, as most of us know, operate the Call of Duty and Overwatch esports leagues. In 2018, the Department of Justice opened an investigation concerning the so-called competitive balance tax implemented by Activision for its esports leagues. And this tax was essentially a soft salary cap. It discouraged teams from excessive spending on player salaries by imposing a penalty on any money spent above the cap. So for instance, in 2020, the salary cap for teams was $1.6 million. The penalty functioned in a way that for every dollar spent above these $1.6 million, the non-compliant team would have to pay the same amount as a penalty. So for instance, if a team spent $2 million on player salaries, it had to pay a $400,000 penalty, which was then distributed among the complying teams. And based on the DOJ, this tax had the purpose and effect of limiting competition between the teams in each league for esports players and suppressed esports players' wages. As part of its investigation, the DOJ spoke to teams and found that teams would have spent more absent this tax, and the tax minimized the risk that teams would substantially outbid for each other for a player, thereby obviously reducing competition between teams for players. So for instance, if there would be a risk that a competing team would poach one of your players, but they couldn't spend any more money, this risk was taken away by that tax. Some of you that also follow not just esports, but also sports might say many sports leagues maintain salary caps. Where is the difference? The DOJ addressed this by saying in sports, players have unions, and through the collective bargaining agreements in place between the player associations and the league, the players essentially agreed to these salary caps, whereas in esports, we don't have unions or not effective unions, and therefore it's not the same situation, and players did not agree to the salary cap. What may be quite interesting to note in this context is that Activision Blizzard actually abolished the tax prior to the settlement with the DOJ, and it never actually enforced the tax, meaning it is sufficient for the antitrust infringement that the general mechanism was in place. Whether executed or not is actually irrelevant. This is mainly because the tax nevertheless had an effect by limiting the spending of teams, meaning the penalty did not need to be exercised to give the rise to an anti-competitive effect. If we now translate this to European and German competition law, there are two possible avenues to pursue the conduct at hand. The first would be a cartel agreement based on Article 101 TFEU or Paragraph 1 GWB, which is the German competition law statute. The cartel offense arises because Activision and the teams essentially coordinated their behavior concerning player salaries. In the words of the Department of Justice, Activision and the teams agreed to impose rules that had the purpose and effect of substantially lessening competition for players by suppressing player compensation. The second plausible avenue is an abuse of dominance based on Article 102 TFEU or Paragraph 19 GWB, which concerns the unilateral conduct by Activision to impose anti-competitive conditions on teams concerning the player salaries. This is, for instance, covered by Article 102B, that prohibits the direct or indirect imposition of unfair trading conditions, or from a German perspective, Paragraph 19.2.2 GWB, which prohibits the imposition of terms and conditions of business that deviate from those which would very probably result from effective competition. Effective competition is something we would no longer have, as Activision artificially dictated the maximum spending for player salaries. So far, we have covered player salaries, but what may be more interesting are the other aspects that the DOJ considered in passing. Namely, 4 important points that I want to briefly outline before explaining their wider implications. You have the direct quotes from the DOJ on the slide. First, the DOJ noted that fans in esports are not just concerned with playing, but also with watching streams on Twitch and YouTube, as we all know. Second, in assessing how publishers monetize, the DOJ considered franchise fees, sponsorships, and streaming and broadcasting as relevant competitive parameters and revenue streams. Third, the DOJ considers the hiring as well as the retention parameters of players. So it's not just important whether you compete about getting a player into a team, but also the conditions that make a player stay in your team. And lastly, the DOJ quite rigorously protects athletes due to their short careers and their limited time to maximize their earnings. These 4 factors bring me to the relief measures stated in the court filing. I'll first read out the section and then discuss each of the highlighted phrases and its wider implications. The United States requests that this court permanently enjoin and restrain Activision from agreeing to or enforcing any rule that would directly or indirectly impose an upper limit on compensation for any player or players in any professional esports league that Activision owns or controls, including any role that requires or incentivizes any team to impose an upper limit on its player compensation or imposes a tax, fine, or other penalty on any team as a result of exceeding a certain amount of compensation for its players, and requiring Activision to take such internal measures as are necessary to ensure compliance with that injunction. To break this down, what this essentially means, agreeing to or enforcing any rule means that it's entirely irrelevant whether Activision or any other publisher for that matter actively engages in potentially anti-competitive conduct. It is already sufficient if such potentially anti-competitive conduct is included in some form in any agreement that is part of a particular esports ecosystem, which highlights the importance of competition compliance. Directly or indirectly means that it's sufficient if a potentially anti-competitive objective is achieved somehow. The method of achieving it is entirely irrelevant to the DOJ's assessment. Imposes an upper limit on compensation is very important, as despite this whole case being about a salary cap, the DOJ chose the arguably wider wording of compensation in its filings, meaning that other parameters that may feature into a player's ability to monetize may equally be caught by this injunction. Furthermore, it's irrelevant whether a rule requires a stakeholder in an esports ecosystem to engage in behavior that may be anti-competitive. It's already sufficient if a certain rule incentivizes such conduct. And lastly, whether the anti-competitive objective is brought about by imposing a tax, fine, or other penalty is essentially the DOJ's wording of, we don't really care as to how you do it. If you do it, then this is already a problem. This brings me to the wider implications of this settlement. If the conduct in question by Activision Blizzard is considered to be anti-competitive, this obviously permits for the assumption that the same or similar conduct that has the same or similar effects may also be considered anti-competitive by competition authorities. Given the wider approach the DOJ took concerning compensation and the fact that it considered Twitch and YouTube as relevant to its competitive assessment, it's plausible that restrictions concerning the compensation derived from streaming or content creation may be equally anti-competitive. Such restrictions concerning streaming could include something relating to the type and content of streams, for example, co-streaming prohibitions or restrictions concerning which games or content a player may stream, as well as the timing of such streams, so long as these restrictions negatively affect the monetizability of a player. The restrictions concerning content creation may follow the same principles. Given that the DOJ noted the importance of competition between teams for esports players multiple times, restrictions concerning tradability of players may also be anti-competitive if they lead to a reduction of competition between teams, which the DOJ considered to be very important. A hypothetical example for this could be if teams implement a clause during a player trade to not trade the player to a competing team, as this might subsequently reduce the competition between the team trading the player and the other team that is not permitted to acquire the player. Also, as the DOJ noted, the importance of franchise fees and sponsorships may also be the case that restrictions relating to sponsorships and advertising may be found to be anti-competitive if they restrict the monetizability of players and teams. This may be, for instance, the case if dissimilar conditions are applied between the publisher and esports teams in the acquisition of new sponsors. Lastly, as the DOJ emphasized the importance of the player's ability to maximize their earnings, restrictions that hinder the player earnings generally may be found to be anti-competitive, as the DOJ had a clear priority in protecting athletes in its filings. That was one of its most important concerns. To summarize these implications essentially in one sentence, competition compliance concerning contracts and agreements in esports and gaming ecosystems may provide some regulation of the esports sector that we may not have in other parts of the esports sector. And with that, I would open the floor to any questions you may have, and thank you for your attention.
Thank you very much, Fabian. Very interesting, especially the wider implications. Wouldn't have thought about it this way until now.